When you're buying a business, the principle of caveat emptor or buyer beware will apply. The general law doesn't offer any protection in relation to the inherent risks in such a transaction. Therefore, buyers seek to protect themselves through their contracts, and they do this by introducing warranties and indemnities. However, the two terms are often mixed up or used interchangeably, where there are in fact significant differences between the two. A warranty on one hand is a statement as to the condition of business or assets, the subject of the deal. It will give an entitlement to sue for damages in the event of breach, but the entitlement to recover is limited, as I will explain later on. An indemnity, on the other hand, is a promise to reimburse somebody euro for euro in respect of their cost they incur in relation to remedying the specified loss, the subject of the indemnity. And again, I'll explain in more detail the difference between the two. A warranty is a contractual statement as to the condition of a business or assets, the subject of the particular deal. In a typical M&A transaction, the warranties can be very extensive and wide-reaching and can run to 40, 50, 60 pages of a contract. Obviously, the extent and the nature of the warranties will very much depend on the particular deal in question or the business or assets that are being sold. In the event of a breach of warranty then, that will give rise to an entitlement to sue for damages. The purpose is to put the innocent party back in the position they would have been had the breach not arisen. The maximum damages available will be your loss of bargain. Therefore, if you purchase a business for €100, the maximum damages that you can recover will be €100. Even though the cost to you of remedying one or many breaches may far exceed that. A warranty therefore acts as a kind of retrospective price adjustment mechanism. It will be a matter for the buyer to demonstrate, to prove the breach and to demonstrate the loss they have suffered as a result of that breach. An indemnity is a promise to reimburse an indemnified party in relation to a specified liability or risk that may arise. It is a promise to reimburse euro for euro the cost to the indemnified party of remedying or of that scenario. The purpose is to shift risk back onto the seller. And indemnities in M&A transactions will generally be only used in relation to specific areas of concern that have been identified. So warranties will be wide-reaching across all areas of a business, but a breach of warranty claim, as explained, may not adequately compensate for the actual cost of remedying that breach, whereas an indemnity will be a guaranteed compensation euro for the actual cost incurred in relation to the specified liability relating to that indemnity. So there are some notable differences between the use of warranties and indemnities. As mentioned, warranties will be extensive and wide-reaching, but the limitations on liability are common with warranties, often hotly negotiated at negotiation stage. Common limitations will include limitations as to the period within which you can make a claim, a de minimis before you can make a claim, a maximum quantum for claims, etc. Indemnities, on the other hand, tend only to be used in relation to particular specified areas of concern, and no limitations are generally permitted in respect of them. Under common law, there is a duty to mitigate one's loss in respect of a breach of warranty. There's no analogous duty in respect of an indemnity. So it's worth noting that while warranties are very extensive, they are no substitute for having carried out a thorough due diligence in advance. Warranty claims tend to be relatively rare, and for that reason, because that procedure allows for all cards to be put on the table. If a buyer wants to proceed, notwithstanding having been made aware of certain issues, they can then look to protect their position by trying to impose indemnities in respect of that particular issue.